So hi everyone. In the last class we have discussed about the contract of the bailment and we have discussed who is the bailer and who is the bailee. Okay. So under this bailment and the bailee concept we have discussed that how the concept of the bail works, that how the person is called the bailer who gives the any specific thing as the per the concept of the bailment, and the person who gives the goods, who is the provider of the goods, is called the bailer, and the person to whom for the specific purpose the goods has been given, that person is called as the bailee. Okay. For example, we have discussed I am giving my clothes for the dry cleaner, for the purpose of the dry cleaning to the dry cleaner. Okay. So when I provide my clothes or when I give my clothes to the dry cleaner, then I become the bailer over here, and the person who receives my clothes, that person is called the bailee over here. Okay. So once the specific purpose is done, the bailee must return the goods to the bailer. This is the specific purpose that has been explained under section 148 under the concept of the bailment. Okay. So we have clearly discussed what is the bailer, what is the bailee, and what is the concept of the bailment. Okay. Moving forward, under section 149, there is the another question arises that how is delivery to bailee done? That when we are talking about the delivery of the goods to the bailee, then how the delivery has been done. Okay. Under that, we have discussed that the delivery happens when the goods are given to the bailee or to someone authorized to receive them on behalf of the bailee. So, under section 149, it is spoken that the delivery of the goods happens when the goods are given to the bailee, the first thing, or someone authorized to receive them on behalf of the bailee. Either there is a person who is the bailee is receiving the goods, or someone who is authorized on behalf of the bailee to receive the goods. When they specifically the receipt of the goods has been done, then it will be considered as the completion of the delivery to the bailee. Okay. Then comes, we have discussed under section 150, under which we have discussed the bailer's duty to disclose the faults in the specific goods. That is explained under section 150. And under that, we have discussed that the bailer must tell the bailee about known faults in the goods that could interfere the bailee's use of the goods and expose the bailee to risk or harm. Okay. So when we are talking about section 150, it exactly specifies that when I am the bailer, you are the bailee, and I am providing you something, I am giving you something. So when you are receiving the thing from me, you becomes the bailee, and when I am giving you the specific thing, I becomes the bailer. Okay. So if the bailer feels that there is any kind of the faults in the specific goods, okay, and that specific fault in the goods can interfere with the bailee's use of the goods. For example, if you have given me something and I have received that specific thing from you, but I realize that as the bailer, if I would have informed the bailee about the fault in the specific product, then it would not interfere the enjoyment of the bailee in the specific product. Then it is my responsibility, my duty to inform the bailee about the specific fault in the specific goods. Okay. So, okay. So, according to section 150, as we have discussed, it is the duty of the bailer to inform the belly about the faults in the goods. Okay, and if the fault in the goods, if it is been felt by the beller that the fault can interfere with the belly's use of the goods or expose the belly to the risk or harm, then it is the duty of the beller to inform the belly about the fault in the specific goods, or else the beller will be responsible for the loss or damage of the belly. For example, uh, I am giving, for example, that take an example of this. I am using any electronic instrument. Okay, so I have been giving that electronic instrument to my friend for the specific use, and I am giving it to her, and I am telling her that you have all rights to enjoy this. You just enjoy this, okay? You take care of these goods, and you can just enjoy those all the kinds of the goods of mine. But I know that in one of the electronic instrument there is the fault that when it comes in contact of the water, it creates current and it might harm to the person who is using. Okay, like there is certain default in the electronic system of any gadget, and it might give the electric shock to the person who is using it. I have the idea about it, I know about it, even I have experienced this. But still, after knowing that, I did not inform the belly about that. I didn't tell her about the fault in the specific product to the belly. So when the belly started using that specific things of mine that I have given to her, she got an electronic shock and she got hospitalized. So here you tell me, who will be responsible for this condition of the belly? Of course, the beller, that means me. I had the primary idea that this electronic thing or this electronic instrument is going to harm the belly if she is not aware about the dangerous aspect about this thing, about this electronic instrument. She has no idea about that. But I knew that this is going to harm the person who is going to use this. So it was my responsibility to warn the belly about this specific goods, that this might create the electronic current, or this might be harmful to the belly. But instead of knowing this, I did not inform the belly anything, so that the belly used that specific product and she faced the problem, or she had been hospitalized. So here you tell me, who will be responsible for all these activities, or who will be responsible for the losses or damages caused to the belly? The answer is beller. Here, as a beller, I will be responsible for all the losses and damages that had been occurred to belly due to my negligence, because it was my primary duty, primary intention to clarify the belly about the fault in the product or fault in the system. But I did not inform the belly about that. So it is my fault not to inform him about that, and that is why I am responsible for the loss or damage. Got it? So when it is about the paid bailment, okay, as like I told you before, that when the bailler has the idea about the default in the system or default in the product, and the person who is the bailler is not informing the belly about that, then in that case the bailler will be responsible. But just twist the situation. What if, what if the bailler is not aware about the fault in the system? The bailler has no idea that there is any kind of the mistake or there is any kind of the fault in the specific good, and he is giving the belly that specific product with a belief that this product is totally fine and perfect to use. He has no primary idea that this product lacks any kind of the productivity or any kind of the system guarantee, or any problem is with that product. The belly do not have any idea about that. Neither the beller has the idea about that. The beller believes that this product is a perfect product, and that is why he or she is giving that product to the belly. So tell me, in this situation, will the beller be liable for the circumstances if the belly is being any causing, if the product causes any kind of the losses to the belly? The answer is yes. If it is a paid bailment, if the belly has paid for the specific product or specific thing, then the bailer will be responsible for all kind of the defects in the specific goods or specific thing, even if the bailer has no idea about the defects, even if the bailer do not know about the specific fault in the thing, still he will be liable, he will be responsible for that. You may ask me how. Just take an example of this. For example, you are hiring a car for the specific purpose of the traveling. There has been the system of the rented car nowadays. For example, I want to travel to some particular places for the purpose of moving around, right? So I do not have my personal car. So what I'm doing, I can take the car for a rental purpose. For example, I am taking the car for the duration of 1 day or 2 day or 1 week. That is my choice, okay? And for that specific duration I am paying a certain amount. It might be for example, per day I am paying 500 rupees, 1000 rupees, or 2000 rupees, okay? So for the specific time period I am paying a certain amount, okay? The first thing. The second thing is, I am taking the car as a rented property. The person who is the owner of the car is renting me the car for the duration of 2 days, 3 days, 1 week, or specific duration of 3 to 4 days. Okay. Whatever the time period may be, and I am paying the specific amount equivalently for the specific car or specific good. Okay. So in this situation, for example, मान लो the car, I have taken the car for the purpose of enjoying it, but unfortunately the car met an accident due to the failure of the brake. Where as a belly, I did not have any idea that the car is going to fall in the brake fail. I didn't know about this. And the bailor, who is the owner of the car, neither he had any idea that the car is going to face any kind of the accident like this due to the brake failure. Got it? So, what we are talking? Yeah. Neither the bailor nor the belly had the idea about the defective brake system in the car. So, like the person who is the belly, he rented out the car and he left for the left for the trip. Okay, but in the middle road, due to the failure of the brake, the car met an accident and the belly got injured. So here, who is responsible to compensate the belly for the losses or damages? The answer is the bailor. Even if the point is over here that the bailor had no idea about the defect system in the car. The bailor did not know that there is any kind of the fault in the brake system of the car, but still the bailor will be responsible for the acts. The bailor will be still responsible to the belly for the damages of him. It's because it's because the belly did not know about the fault, and it is the duty of the bailor to provide safety to the belly and checking the systems in a proper manner before going on it. Okay. Then comes your section 151. Okay, and it speaks about the belly's duty to take care of the goods. So when we are talking about the duty of the belly to take care of the goods of the bailier, then how does it works? The belly must take care of the goods as an ordinary careful person would take care of their own goods of the similar nature. So what does it mean? It means it is the duty of the belly to take care of the goods of the bailier as an ordinary careful person would take care of their own goods. If I am an ordinary person, the way I take care of my own goods, the belly must take care of the goods in the similar manner, in the similar way. Okay? For example, you are the bailier. You have given me your watch as the belly for the specific purpose of repairing it. Okay? And I have repaired your watch and I have to send it back to you once I am done with the work of the repairing. During the time period while I am keeping your watch for the purpose of repairing it, I have my duty and my responsibility to take care of the goods as like it is my watch. The way I would have take care of the watch of mine, the way I would have protect my own watch, I have to take care of your watch in the same manner, in the same circumstances, and in the same way. Okay. Then comes section 152. It speaks about when is the belly not responsible for the loss of the goods. If the belly takes proper care as described under section 151, they are not responsible for the loss, destruction, or damage of the goods. So, what does it mean? It means if the belly takes proper care as described in section 151, if the belly takes proper care of the goods as provided under section 151, that means the belly has taken care of the goods as like the his own goods. Then even after that, if there is any kind of the losses, damages or destruction of the goods, the belly is not responsible for the damages or losses or to compensate it. So let me give an example of this. For example, you have given me your watch for the purpose of repairing it. Okay. I have kept it under the shelf, under the box with a very proper, careful way. And I have given all my care to the specific thing which you have given me. I did everything from my side what I could. Okay. I did my best to protect your thing. But in spite of that, there is a natural calamities like, for example, there is a flood over there in the city, and due to flood, many more things has been destructed, and your watch also been destructed with other of my own goods. Where my own goods has also been destructed, and as well as your watch has been destructed while it was under the care of mine. So, am I responsible to pay you the damages for the specific losses? The answer is no, because I had taken care of your goods in the specific manner, in the proper way that I could. I did my duty. So, it was not my responsibility, or it was not in my control, not my hand to stop the natural calamities, because I had no idea that this is going to happen. So, the circumstances where I do not have any control, where I cannot stop the situation if I want, where I know that the situation is beyond my control, and even if I want, I cannot stop the specific circumstances, I cannot stop the specific situation, then in that specific situation, the belly is not responsible or not liable for the losses or damages of the goods. Got it? Then comes your section 153. It speaks about the bailor can end bailment if the bailee breaks the terms, and it is explained under section 153. What does it speak? If the bailee does something with the goods that is against the agreed condition, the bailor can end the bailment. What does it mean? It means if the bailee does something with the goods that is against the agreed condition. That means if then the bailor can end the bailment. For example, I have given you the watch of mine for the purpose of repairing, and it is the terms and condition between us that you can keep the watch for the purpose of repairing it only, and in return I am ready to pay you. Okay, the first thing. Second thing, you have to return the watch of mine once you are done with the repairing work of the watch. But instead of returning me after the process of the repairing, you started using the watch by yourself. So this is the breach of the terms and condition that has been primarily decided. It has been primarily decided that you have to return the watch to me once you are done with the repairing stops. But even after the process of the repairing, still you are not giving it back to me. You are still keeping the watch with you. So here, if the bailee does something that the good is against the agreed condition, the terms and condition of the contract that has been agreed before, the process, the things that the parties has mutually decided before, that this is the thing we are deciding, we have to do this, where the parties had primarily decided something that yes, we are going to work on this, we are going to do this, but even after deciding the specific thing, the parties are doing something else, or the bailee is not obeying, is not following the terms and conditions, the bailee is breaking the rules of the bailment, then in that specific condition, the bailor has the right to end the bailment. यहाँ पे bailor क्या कर सकता है? The bailor can end the process of the bailment and take the goods back. As the bailor is the original owner of the goods or the specific thing, he can take back his property or his specific goods from the bailee if the bailee breaks any kind of the rules or regulation or terms and conditions in the specific mode of the contract. Got it? So, then comes section 154. It speaks about the liability of bailee for unauthorized use of the goods. When we are talking about the unauthorized use of the goods, then in that specific cases, how the bailee is liable for that, responsible for that, we are going to discuss that. Okay. If the bailee uses the goods in a way that was not agreed upon, they are responsible for any damage caused. So how does it speak? If the bailee uses the goods in a way that was not agreed upon, they are responsible for any damage caused. For example, there is the specific terms and condition that has been fixed by the party to use the goods or the specific products. But the bailee is violating the terms and conditions of using it. He is doing something which was not primarily permitted. He is doing something which is out of the context, which is out of the rules, out of the regulations. So here, when the bailee breaks the rules, the regulation, the terms and the conditions that has been agreed upon, then they are responsible for any damages caused. For example, uh, okay, okay. For example, I have given you my bike. Okay, you are asking me that, ma'am, I need your scooty for the specific purpose of the traveling. Because I need your scooty, I am traveling to my college on a regular basis. So can you please give me your scooty for the duration of 1 month? I said, okay, fine. You are facing certain kind of the issues, so I should give it to you. So what I did, I have given you my scooty. According to section 153, if we are going for that, instead of using the scooty for the purpose of traveling to your college, you used the scooty for the purpose of a long drive. You took the scooty and went to 300 kilometer or 400 kilometer. I have warned you before that the scooty cannot travel a long distance because the scooty has certain faults. So do not use the scooty for the purpose of long driving. You can use it for the traveling purpose in your localite areas only. Even after my clarification, even after my warning, still you are not following my instructions, still you are using the scooty for the purpose of long drive or any other usage. So here, when I get the knowledge about this, when I know that you are misusing my scooty, you are not following the rules and regulations that I have instructed you, then I have all my rights to terminate the contract, to end the contract with you. I have my right to end the contract of the bailment with you, and I have right to take back my scooty from you because you are violating the rules of the contract. And according to section 154, this was the thing I told you that was under section 153. Under section 154, it is seen that if after using the scooty, if there is any kind of the damage is being caused, for example, the scooty is broken. While taking in the long drive, the scooty made an accident. The scooty discovered any kind of the fault or damages in that specific situation or the circumstances. What will happen? In that situation, in that situation, the bailee is liable to compensate the bailer for the unauthorized act of the goods. The bailee is responsible for any damages caused because here the scooty has been given by the bailer to the bailee for the purpose of traveling to the local areas, not to the long distance things. But even after the warning, the bailee used the scooty for the traveling of a long distance of 300 kilometer or 400 kilometer, which was beyond the capacity of the scooty, and that is why the scooty failed to take the pressure and it caused the damage to the scooty. So the amount that will be taken in the process of the repairing of the scooty, that must need to be repaired by the bailee only. The bailee is responsible, mandatorily responsible to pay the bailer for the specific damages or losses over there. Okay. So when we got to know, according to section 153, if there is any kind of the violation in the terms and conditions, the bailer has the right to terminate the contract, as well as when there is any kind of the loss or damage to the bailer or his property due to any kind of the irresponsible activity of the bailee, then the bailee is responsible for any kind of the damages caused. He is responsible to pay the bailer for the damages. This is explained under section 154. Okay. Then comes 155. So when we're talking about 155, it speaks about the mixing of the goods. So when we're talking about the mixing of the goods, it has been explained from section 155 to 157 of the Indian Contract Act. Okay. So the first point, section 155 speaks about mixing of the goods with the consent of the bailer. In 156, it speaks about the without the consent of the bailer. And under section 157, it is spoken about when it cannot be separated. So how does we are going to deal with this? The first thing, with the consent of the bailer. That means that is explained under section 155, and it is spoken that if the goods are mixed with the beller's consent, then the beller and the belly share the mixture based on their proportion. For example, as the beller, I am providing you something, I am giving you something, okay? And there is a mutual agreement between the beller and the belly. There is the mutual agreement between us that our goods can be kept together. Can be kept together. This is the agreement between you and me. So when it is it comes about the taking back the own goods, then the proportion in which the goods of the beller and the belly had been mixed, it will be separated accordingly. If the proportion was 3 is to 4, then the goods had been separated in the comparison of 3 is to 4 only. Got it? So this is called the mixing of the goods when happens with the consent of the beller, then the goods are mixed with the beller's consent, both the beller and the belly share a mixed based on their proportion. And when it comes about separating the thing from one another, then the proportion under which it had been mixed, the proportion in which it had been mixed, on the similar proportion it must need to be get separated. Got it? Then comes when when it happens without the beller's consent. This is explained under section 156. On that, it what is fixed? If the goods are mixed without the consent but can be separated, the belly must hear the cost and any damages caused. Okay. So when I'm talking about the consent of the belly's consent, when it has been mixed with with the product of the beller, then the proportion under which it has been mixed with the similar proportion, it need to be separated. But if the mixing of the things that has been done without the consent of the beller, then the belly must bear the cost or damages that has been caused. Okay. So, for example, uh, take an example. There is the 100 cotton balls of the baler, okay, and it has been mixed with the 200 cotton balls of the belly, and it has been done with the consent of the belly only. So, from that 300 cotton balls, certain specific product has been produced. So where here the ratio is 1 is to 2. The beller is providing 100 cotton balls where the belly has provided 200 cotton balls. And here with this mixture, the specific product has been produced like the clothes and something like that. So here the benefit that will be arisen from this, the beller will be responsible to take the one proportion and the belly will be responsible to take the two proportion, because the cotton balls the cotton balls amount comparison was 1 is to 2. So here the beller is responsible get the proportion of 1, where the belly is responsible get the proportion of 2. But under the second situation, when the 100 cotton balls of the beller has been mixed with the 200 cotton balls of the belly, and it has been done without the consent of the beller. The beller did not have any idea that his cotton balls has been mixed with the product of the belly, and he is disappointed with this. He is not happy with this. Then here the belly must liable to bear the cost and damages caused to the beller. That means the amount of 100 cotton balls, the price of the 100 cotton balls, that must be need to be paid by the belly to the beller. Here the belly is liable to compensate the beller for the losses or damages caused to him or her. Okay. And under section 157, If the goods cannot be separated, the belly must compensate the beller for the loss. And under section 156, if it can be separated, it will be separated, and even after the separation, any other specific damages is left, then the belly must bear the cost or any damage caused to the thing. For example, 100 cotton balls of the beller is been mixed with 200 cotton balls of the belly. So here the 100 cotton balls which has been mixed with the 200 cotton balls of the belly, first it will be tried to be separated. If it can be separated, then well and good. But even if after the separation it is seen that, for example, the amount of 500 rupees of the losses that is being bear by the uh, beller. So here the belly, along with giving back the 100 amount of the cotton balls, or the 50 amount of the cotton balls had been discoverable, left 50, the belly could not found it. It has been mixed properly, so it is unable to recognize. So in that specific circumstances, the belly is liable to pay the damages or the cost for the 50 other left 50 cotton balls. The damages or the cost must be paid. But if it is the situation that the cotton balls are so mixed that is unable to identify the beller's cotton ball from the belly's cotton balls, and it is in and it cannot be separated, it is unable to be separated. So here the beller is the beller is liable to get the compensation from the belly for the losses or damages of him. This is explained under section 155 to 157, which explained that when the mixing of the goods happens with the consent of the beller, then what happens? Then the both and beller and the belly shares the mixture based on their proportion. Under section 156, if it is mixed without the beller's consent, the mixed product will try to be separated first, and the left co- cost or damages must be paid by the belly, or the belly must bear the cost or the expenses, damages cost. And under section 155, 157, if it cannot be separated at all, it cannot be separated from each other, then in that specific circumstances, the belly must compensate to the beller for the losses or damages of the beller. So this is about section 155 to 157 of the Indian Contract Act. Then comes section 158. It speaks about the necessary expenses. If the belly is not paid for their work but incurs necessary expenses, the beller must repay them. Okay. For example, I am working under the bell. For example, you are the beller, I am the belly. I am working under you. No. Take another example. For example, I am a dry cleaner. Okay. You have been, I have been hired by you for the specific purpose of cleaning your clothes. Okay. And taking care of your clothes, just washing it, uh, giving it iron and keeping it safe. I have been hired for the specific task of that. So you are the beller over here because you are providing me your clothes as the bellment, and I am taking your clothes and I am washing it, I am giving it iron, and I am keeping it under the safety conditions. So while doing my work, I got that there are certain kind of the the clothes needs the pest control protection. If I am not doing this, then the clothes will be destroyed. So I used the pest control to protect your clothes. Though the expenses of the pest control system that incurred me up to the amount of 2000 of the rupees. So here as a beller, you have to pay me that specific amount of the 2000 of the pest control system. because I have bought that pest control system for your safety, for the for the safety of your goods, for you only, for the bill, for the as a belly I have expensed that amount for the bailor. So the bailor has the responsibility or the liability to compensate me, to pay me those amounts which I have expensed for himself or herself. This is explained under section 158. From section 159 onwards, we are going to discuss in the next class. This is all for today, guys. We can close the class over here. Thank you. Bye bye. Take care.